It's so brief. It's only like a page and a half because it has so little to say on substance. The first interesting part, it's the way these courts lie to us, lie to our faces, because they believe, and often correctly, that we're ignorant. We're ignorant of what the law actually provides. They just lie to our faces. This judge does it here. Before the court is petitioner's ex parte, meaning the government's not represented here, application for a temporary restraining order. The court, Judge Gallagher, on the bench 2 years, finds it appropriate for these preliminary proceedings for petitioner to proceed as next friend. What's that mean, next friend? I have to tell you, folks, I've been practicing law for 34 years, including as a member of the Supreme Court bar. And until I saw this order, I'd never seen any reference to this legal doctrine of next friend. Because who's filing this petition? Someone called Susanna Vortson. Not the bomber, not his family, not a lawyer, or at least not a lawyer allowed to practice anymore because of her misconduct in other states and other immigration cases. Spoiler. She says, well, I'm not actually involved in this case. I'm not representing the parties. I'm not going to suffer injury here personally. So normally I would have no standing. To be a party in court, you have to be at risk of suffering some loss. Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you. She says, well, I'm going to file for this TRO as a next friend. Well, what's that mean, next friend? This court finds it appropriate for these preliminary proceedings to proceed as next friend because the filings indicate there is no means to contact the family of the bomber, and petitioner has a significant relationship to her. And then it says, see Whitmore v. Arkansas, a U.S. Supreme Court case from 1990. Now, you might think from this that Whitmore v. Arkansas is a Supreme Court case that involves the doctrine of next friend and allowed for standing, because that's what's happening here. That's what you would think. Whitmore, see Whitmore v. Arkansas, in support of this position that this woman, a disgraced immigration lawyer, prohibited from practicing law in, I believe it was South Dakota because of misconduct, that this woman can act as next friend here, and that's supported by this U.S. Supreme Court decision of Whitmore v. Arkansas, right? Guess what, folks? I went and I read Whitmore v. Arkansas. Let's take a look at what Whitmore v. Arkansas really had to say. Really had to say. I've got a little summary here for all of us. Whitmore v. Arkansas. So first of all, this was a case on death row, which are always tough cases, and tough cases often make for bad law. But there was a man on death row. He was about to be executed. There was another man on death row, his friend. And the man about to be executed, he said, all right, I'm all done with the legal process. I'm ready to go. I'm ready to suffer capital punishment. But his friend didn't want him to go. So his friend went to court as a next friend and said, I want to file an objection to this upcoming execution as a next friend of my death row buddy. Let's take a look at the official overview of this case. A prisoner was convicted of the murders of 16 people and sentenced to death row. He stated under oath that he wished to waive his state court appellate review and that he wished no one to interfere with his death sentence. Petitioner, Whitmore here, a death row inmate with this dude, unsuccessfully sought to intervene as the person's next friend. This was an unsuccessful next friend petition, which this Judge Gallagher cites in his order in a manner that you would think it supports a next friend petition. It's the opposite of that. The Supreme Court found that the petitioner had not met the requirements of a next friend because he had no special relationship with the prisoner and because the prisoner was under no disability that would prevent him from pressing his own legal claims. Quoting now from that decision. Decisions applying the habeas corpus statute have adhered to at least two firmly rooted prerequisites for next friend standing. First, a next friend must provide an adequate explanation, such as inaccessibility, mental incompetence, or other disability, why the real party in interest cannot appear on his own behalf to prosecute the action. In this case, petitioner Whitmore lacks standing to proceed in this court, and the writ of certiorari is dismissed for lack of jurisdiction. So there has to be a showing that the person the next friend is standing in for is inaccessible, is mentally incompetent, or otherwise disabled from the legal process. These people have been grabbed by immigration. They are in the proper legal process. That is the due process to which they are entitled, to which Congress has assigned them. Congress has explicitly stripped from the federal district trial courts jurisdiction over immigration matters and assigned it to the immigration courts. These people are in custody of the immigration courts. They are getting every drop of due process to which they are entitled and more. They are not inaccessible. They are not inaccessible. They are not mentally competent. They're not suffering some other disability. They are exactly where they are supposed to be in the immigration courts. And this judge is doing this scheming claiming this next friend status, which does not legitimately exist here, as is told to us by the very case he cites. He's lying to us. If this were a law school student doing this on a paper, he should be thrown out of school. It's utterly contemptible. So this judge would not normally have jurisdiction over these people. And he's saying, well, I do have jurisdiction over via this next friend doctrine, which does not apply here. Does not apply here. These people are not being denied any of the due process to which they are entitled, and they're not entitled to quote unquote due process in this guy's court. He does not have jurisdiction, and he's using smoke and mirrors and maliciously misciting Supreme Court case law to suggest to uninformed people or to people who don't make the effort to look that somehow he has jurisdiction. He has no jurisdiction. And then he does this other BS that all these lawfare judges are doing to try to stop Trump. He claims he has authority under the All Writs Act. Again, this is effectively a lie to the face of the American people. There is a thing called the All Writs Act, and it says the federal courts have the authority to issue all writs, all orders, court orders, where they have jurisdiction. But the first question is, do you have jurisdiction? And if you don't, the All Writs Act cannot help you. The All Writs Act is not a backdoor to say you have authority. The All Writs Act only says you can issue orders where you have authority. But the first question has to be answered in the affirmative. Do you have authority? Do you have jurisdiction? If you don't have jurisdiction, the All Writs Act does nothing for you. Nothing for you. And this next provision, Federal Rule of Civil Procedure 65B, is where people are supposed to put up a bond if they're asking for a TRO. But the courts have self-created the authority to waive that statutory requirement, as they have in every one of these lawfare cases, or where they don't waive it completely. They say, it's $100. Put up a $100 bond, completely nominal bond. So pursuant to the All Writs Act, which does not give this court authority to do anything, lacking jurisdiction, which he doesn't have, defendant shall not remove Hayam El Gamal and her 5 children, all here illegally. This Boulder terrorist, his wife, and their 5 children. I tell all of you that there are 100 million illegal migrants in this country, and everyone laughs. No, that can't be, Andrew. That's impossible. That's ridiculous. Look at this. These people are consuming scarce American resources, housing, employment, healthcare, education, cash money, benefits that obviously then are not available for American citizens. He brought his whole damn family here illegally. This is what we're paying for. You feel like apartment rent, housing costs are too high in your community? You feel like the ER is too crowded? You're wondering why half your child's school doesn't speak English? That's why. Moreover, the court finds that deportation without process, again, he's lying to our face. They're getting the due process to which they are entitled. Illegal migrants and American citizens are not entitled to the same due process. They're just not. But the court finds that deportation without process could work irreparable harm, and an order must issue without notice to the government due to the urgency of the situation. What's the irreparable harm? Deportation? They're not entitled to be here. You being denied something you're not entitled to is not harm. That would be like saying someone sentenced to prison is suffering irreparable harm when they've been convicted. Of course it's harm. Of course they don't want to do it. They'd rather be free. These people would rather stay in America. That doesn't mean their lawful deportation is irreparable harm just because they don't like it. None of them like it. They all have to go home. To the extent they have not yet done so, petitioners' counsel, which at this point, there is no counsel. There is no counsel. Now, since then, they have counsel from a very high-powered private law firm. Of course, Emmanuel Quinn, one of the top 20 law firms in the world, doing pro bono work against America's interest, as usual, for these illegal migrants. But at this time, they had no lawyer. This is a next friend appearing in court, a disgraced lawyer who cannot practice. To the extent they have not yet done so, no later than today, petitioners' counsel is directed to, hey, let the White House know that I'm seizing authority over the Article 2 executive branch of government. Me, Judge Gallagher, on the bench for 2 years, whose nomination was approved by a 53-43 vote of the Senate. So now he wants the illegal migrants to explain them. By the way, he says here that there's a next friend. There's a next friend who has a significant relationship to the mother, the illegal migrant mother. What's the nature of that relationship? He says not a word about it. Not one. There is no factual statement of this, which is a requirement for next friend status. Not a word about it. Just summarily claims it. So then the petitioner, the illegal family of the Boulder bomber, their counsel is supposed to file a memorandum in support by tomorrow. And then the White House is supposed to respond a week later. And we'll just kind of slow walk all this through the courts, as we always do. Here's the woman who filed as next friend. Susan Vortkin. Guess who got banned from practicing law in 2019 for immigration misconduct? The attorney for the illegal immigrant family of the Egyptian terrorist. How many Egyptians does America need to import? How many do we need to have here on an illegal status, firebombing our American citizens? Do we need even one? Do we need him to bring his whole family over here? Is that in America's interest? By the way, every one of these people, everyone, the entire family is counted in the census for House seats for Colorado. Colorado, which has gone hard California. Supermajority Democrats at every level of government. They have House seats they would not have but for the census counting these illegal migrant terrorists among the state population. So even if they don't vote illegally, and we know many of them do, Colorado, by the way, is mail-only voting. Ballots get mailed out to every human being in Colorado. You think they're not voting? All they got to do is drop it in a mailbox? Even if they're not voting, which I don't believe, the Democrats, the progressives, those who want to replace American citizens with tens of millions of third worlders, they have 30 to 40 House seats in the U.S. Congress they would not have, but for the fact that we have entire families like this living illegally within our nation. Back to this disgraced lawyer. In 2019, the South Dakota Supreme Court prohibited Susanna Vortkin from practicing law in the state due to misconduct concerning an immigrant matter. The U.S. Department of Justice went even further in 2019 and banned her from practicing law before the Department of Homeland Security. The order? Vortkin is immediately suspended from the practice of law before the Board of Immigration Appeals, the immigration courts, or the DHS. That's the woman who is the next friend authority that Judge Gallagher wrongfully used to claim jurisdiction over this matter. You think he didn't know? You know how we'll know if he didn't know? If he was misled by this woman, he would sanction her. Think that's going to happen? And then we get the more propaganda lies from the left, more emotion, more estrogenic, neurotic hysteria. This person asks, be brutally honest. Do you believe that the wife and children of Mohammed Sabri Salman, the Boulder terror suspect, there he is with the firearms, quite the suspect, he confessed, should be deported? And that if a husband commits a crime, his family should also bear the consequences, yes or no? These people are either too stupid to not be able to ask the right question, or they know it's not the right question, and they're just engaged in pure propaganda. Because this is not the right question. The question is not, should wives and children be punished for the crimes of their husband and father? The relevant legal question is, were these people subject to deportation before their father set a bunch of people on fire? The answer is yes. They were here illegally. They are subject to deportation. If they were subject to deportation the day before their father set a bunch of people on fire, do they become immune from deportation because their father set a bunch of people on fire? Did their Did their immigration status change in their favor from illegal to legal because their father set a bunch of people on fire? Obviously not. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.